What happens when a tenant is racing against the clock? The rent keeps stacking up, and the courtroom becomes the final battleground. Today's case is a pressure cooker. Missed deadlines, denied assistance, and a judge forced to balance fairness with the law. Stay with us, because what sounds like a simple move out turns into a costly legal lesson that affects renters everywhere.
That
No.
this is a horrible day. Okay. And where are we on this one? She said she was moving by the 31st.
I've been moving, Your Honor, but I've been doing this all by myself. So I was intending to have keys back to them on Wednesday, which is the last day of my lease. That unfortunately did not happen. I was there all last night till like 2:00 this morning, moving stuff. I got back up this morning, called off work, and I've been there all day. I had a rather rude call from the apartment complex this morning, asking me about the keys, making threats to me, telling me she'd been in my apartment and asking if I had, intended to leave it in that condition. And I said, well, I didn't give you keys. I'm still in the process of moving out. You didn't have permission to come in my apartment. So like, she's now telling me she's gonna charge me another whole month's rent. And I literally left there with a load of stuff in my car to come here for this hearing. I don't even understand. I mean, I'm kind of like frustrated that they dragged me into court because they're the ones that said they weren't.
Well, ma'am,
I know I owe them. I applied for an SER and they denied me.
Okay, but ma'am, you had said that you were going to move by the 31st.
Yes.
Okay.
And I've been doing everything I can to do so. I'm down to like probably 2 carloads of things. I've been moving stuff with my car all week long. I tried to contact the attorney to be like, look, like I don't have time to be in court because I'm taking off of work to do this. I'm trying to get moved. And they just were like, go to court. Every time that I've communicated with them, they either don't respond to me or they, just are rude.
You're not telling me my office is rude, because I know that's not true.
I contacted them and I said, look, please don't make me have to go to court. Like I'm turning keys in at the end of my lease, like you guys asked to. And she just said, show up in court. And
here's what I'm going to do. I'm not going to, how much is owing through? Well, there was 2737.
3675, including 237 in cost.
How much?
Actually, 3675 plus 237 for 3912. That does include February, because it is February.
Right. And it would be due and owing. I'm going to find after hearing, but there's no.
The days that I have had the keys.
Did they leave? Yeah.
Yes.
Where's the judgment?
I have.
Did you sign it?
Yeah.
I need to look at it before you sign that thing. Stop them before you do that. I'm going to find no tribal issue. I'm going to grant judgment for possession to the plaintiff, as well as a money judgment in the amount of $39.12. Money judgment was requested. That's going to be retroactive back to the date where a plaintiff did not ask for a judgment because you were moving by the 31st. So that's going to take 5 days off of it. You're almost out of the premises. So a writ would issue the 5th or the 6th, excuse me, of February. Thank you.
Sir, I applied for an SER and they denied me, and I didn't even try to bring
They're
that
not
up.
going to, but sir, ma'am, they're not going to pay if you're no longer in the unit.
At the time I applied, I was still there, and they told me that they would not take my summons. That I don't know why he told me that my summons was not an eviction and that they denied me because the summons was.
Okay, but if they took it now, what do you think is gonna happen? SER is not gonna pay this amount.
I know, I understand that I owe them, but I'm trying to keep it down as much as I can because I cannot afford to pay this.
Okay,
I mean, I can't afford to pay the whole February. I did not pay them December and January because I had to use that money to move because they refused to renew my
and
lease.
here's what you do. I've given you to the 6th to get out of the premises.
I'm trying to have keys there today at
If
5.
you're gonna talk, then I'm not going
I'm
to.
sorry.
I've given you to the 6th to get out now that you haven't moved. What I'm going to suggest regarding the monetary portion is that you contact the landlord or Mr. Friedman and arrange a payment plan for that amount. That's the best way to handle this. Okay? SER, Hawk, anybody else, they're not going to pay this. So you arrange a payment plan. I've given you a little bit more time to get yourself out of there, turn in the keys, and you're going to be good.
So then am I gonna have to pay the whole month of February? If
I've included the amount of February in here. You can talk to them about that. February is due. Okay? That's the way it works. Thank you.
We enter into payment plans all the time.
That's right.
So is that also gonna show up on a judgment on my,
Ma'am, yes, it is. Don't wave me like that.
I'm trying to work with them and they were not willing to work with me. I called them, asked them to not cancel my lease and they didn't even return my phone calls.
Okay,
Like I
ma'am.
got bad landlord verifications from them,
I take
so I
it.
couldn't find a move to.
Yeah, that's a part.
Sorry. Like,
Ma'am, I understand the frustration. That's why you didn't get a judgment the last time you were here.
yeah.
I gave you to the 31st. You said you were going to move. I realize the circumstance that you're in now, but I have to also be fair to the landlord.
And I
And
know I'm gonna owe them the money, but every amount that you put on here is just putting me deeper into.
what do
debt.
you want me to do?
I would like to not have to pay the entire month of
Then talk.
February. I would like to have the keys turned in by 5:30 today, which I have enough time to do.
Ma'am, if you turn in the keys, then you have a good argument to talk to them about not having to pay February. The problem is right now, you still have possession of those premises. Your February rent became due yesterday.
And I have a 3-day grace to pay it, which is tomorrow.
Ma'am, I don't know what you're asking in terms of that.
Nothing. I'm sorry. I don't know what I'm asking. Thank you.
Thank you. Oh, she is. Let me step in and get Miss Dornbush moving.
No, I wanted to introduce you to Magistrate Rayleigh, if you just have.
I don't want to do that.
No.
This is a horrible day. Why, you don't bring new people into,
I brought you a ray of sunshine.
yeah, you bring new people in when I'm having a bad day. You knew that.
I didn't know you were having a bad day, but.
No, you did. You could tell. You could tell. You were in here for the last hearing. You could tell.
Rayleigh, she's the new magistrate.
Yes, come on up. I'm sorry.
Judge Cedric Simpson, the senior judge here in 14A.
Senior?
Yeah.
I'm the oldest of all of them. Hello.
Yeah,
Nice to
longest
meet you.
service. And Emily and Anna, his lovelies.
Yes.
And Alan is his other lovely.
Hello. So how's it going?
Oh, it's going.
This case is a textbook example of how good intentions can collide with strict legal timelines, and how quickly housing disputes can escalate once deadlines are missed. From the very beginning, we see a tenant under extreme pressure, juggling work, physically moving her belongings alone, and trying to comply with a promised move-out date of January 31st. Her frustration is real, and emotionally, it's easy to sympathize. But as this courtroom exchange makes clear, sympathy doesn't override legal possession. One of the most important legal distinctions in this case is possession versus intent. The tenant repeatedly explains that she intended to turn in the keys and believed she was nearly finished moving. However, in landlord-tenant law, intent doesn't matter nearly as much as action. Until the keys are surrendered and the unit is legally returned, the tenant remains in possession, and that single fact triggers ongoing rent liability. That's why February rent becomes unavoidable the moment the calendar flips, even if she's down to 2 carloads of belongings. The judge walks a careful line here. On one hand, he acknowledges her circumstances and even credits her for being close to moving out. We see that reflected when he reduces the amount slightly by taking 5 days off the total. That's not something the court was required to do. It's a discretionary effort to be fair. On the other hand, the judge makes it clear that fairness must extend to the landlord as well. Rent wasn't paid for December or January. February has now begun. And the landlord is legally entitled to payment while the tenant still controls the unit. Another critical moment involves emergency rental assistance, which the tenant refers to as SC. This is where many renters get confused. Assistance programs typically won't pay once a tenant has vacated or once the timing no longer aligns with the program's requirements. Even though the tenant applied while still living there, the denial leaves the court with no alternative funding source. The judge is blunt but accurate. No assistance program is going to step in at this stage to cover a growing judgment. And let's talk about that judgment, because this is where the long-term consequences come in. The court grants judgment for possession and a money judgment totaling $3,900, which includes unpaid rent, costs, and February rent. That money judgment doesn't disappear just because a payment plan is arranged. As the judge clearly states, yes, it will show up as a judgment. Payment plans help with collection, not with erasing the legal record. So here's the big question for you watching. Should intent matter more than possession in cases like this? If someone is clearly trying to leave but misses the deadline by hours or days, should the law offer more flexibility, or does that open the door to abuse? And from the landlord's perspective, how long should they be expected to wait while rent goes unpaid? Ultimately, the judge's message is simple but powerful. Turn in the keys as fast as possible. That single action is the tenant's strongest leverage moving forward. Without it, rent continues, liability grows, and negotiation power shrinks. This case isn't just about money, it's about how quickly delays can turn into permanent financial consequences. Final takeaway: deadlines in housing court are unforgiving. Verbal agreements, good faith efforts, and emotional hardship matter, but possession is king. Once rent accrues, courts can reduce, but they rarely erase. And now we want to hear from you. Did the judge get this right? Or should more leniency have been shown given the circumstances? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.